far as liabilities for adopting a smoke-free policy, we really haven't seen any yet. Some people, some managers, property owners are concerned that if they advertise their property as smoke-free and then a tenant rents a unit based on that assumption, subsequently another tenant moves in and is smoking in violation of the policy next to the non-smoker, that then the non-smoker could come after the landlord saying, you advertise this as a smoke-free policy, I have gotten sick from this tenant next door to me, therefore I'm going to come after you because you advertised falsely. We haven't seen any of these claims come forward yet. One of the things we recommend is that landlords use a very clearly defined smoke-free lease addendum, and in the addendum they have some language that is a disclaimer that protects the landlord and basically says that the landlord is not a guarantor of a smoke-free environment. The landlord is making a best effort to provide a smoke-free environment. And the smoke-free lease addendum also states that it's up to the other tenants to inform the landlord if they're aware of a violation. Because frequently the landlord may not be on site all the time, or it could be a very large complex and their unit may be at the other end of the property from where the violation is occurring. So the residents have some responsibility to let the landlord know. So no, we haven't seen any cases where a landlord has been held liable for imposing a smoke-free policy. As far as liabilities, if you remain smoking permitted, we've seen a number of cases that have been brought forward across the country under different kinds of claims. Frequently they come under a nuisance claim, and that'll mean that the one resident is so bothered by the smoke coming from an adjacent unit that it constitutes a nuisance. There have been similar claims brought under a cause of action called the warranty of habitability, where there's so much smoke coming in that it's uninhabitable for that individual. Some of these have been successful. There's also been claims based on disability statutes that I mentioned earlier. So these are a couple of the areas where there is potential liability for a landlord that remains smoking permitted. A lot of landlords now feel that smoking is maybe just a nuisance, such as cooking odors that might come in. But as more landlords become aware of the actual health harms, and as the courts become aware of more of the health dangers of secondhand smoke, I can see that more requirements being placed on landlords to warn individuals of smoke or actively have to take action if smoke is coming into a residence unit. So yeah, I think there are more liabilities with a smoking permitted building than there are for a smoking prohibited one.